All right, let's just jump straight into this. Today, we're looking at a genuinely fascinating constitutional showdown. It's a landmark case out of South Africa that basically tests the absolute limits of religious freedom in a democracy. We're talking about what actually happens when deeply held spiritual beliefs crash headfirst into strict national criminal laws.
To really get a feel for the stakes here, imagine this for a second. You've spent years grinding away to become a lawyer. You put in the brutal hours, you pass all your exams, and you're literally right at the finish line, ready to register for your mandatory community service. But then, boom, you hit a brick wall. And it has absolutely nothing to do with your grades or your legal skills. It's because of your religion.
Well, this wasn't just some hypothetical scenario for Garreth Prince. He was a successful law graduate, sure, but he was also a practicing Rastafari. And in the Rastafari faith, cannabis isn't some recreational thing, it's a sacred plant. It's required for their spiritual, medicinal, and even culinary practices. But because of those deeply held religious practices, Prince had picked up 2 previous criminal convictions for possessing cannabis. So when he went to the Law Society of the Cape of Good Hope to register his contract, they flat out refused him. Since he stated he was going to keep using cannabis for his religion, they officially labeled him unfit and improper to practice law.
And this brings us right to the absolute core of today's conflict. It's a massive direct collision. On one side, you've got the Constitution, guaranteeing Prince's fundamental human right to practice his faith and choose his profession. On the other side, the state's strict anti-drug legislation. And those laws completely prohibit possessing or using cannabis with absolutely zero exceptions for religious use. Let's trace how this escalated, because Prince didn't just quietly take no for an answer. He fought back. He went from the Law Society to the High Court, got turned down, appealed to the Supreme Court of Appeal, got dismissed again, and finally took it all the way up to the highest court in the land, the Constitutional Court. This wasn't just a quick dispute. This was a grueling, multi-year battle testing the very fabric of South Africa's post-apartheid legal system. Now, as you might guess, those lower courts, they consistently sided with the state. The Law Society's stance was pretty straightforward. If you plan on continuously breaking criminal laws, you simply can't be an officer of the court. The state argued that creating a special religious loophole for Rastafari would be practically impossible to police, and the High Court and Supreme Court of Appeal agreed. They totally admitted that Prince's religious freedom was being limited, but they ruled that the limitation was legally justified. They felt a special exemption would just dump an unreasonable burden on police and courts that were already drowning in a general crime wave. But things really shifted when the case finally hit the Constitutional Court. The judges there recognized the profound stakes of this matter. Justice Ngabo pointed out that religious freedom is about way more than just personal conscience. He echoed this powerful idea. Religious belief awakens self-worth and human dignity, which are literally the cornerstones of human rights. The court basically said a democratic state shouldn't ever force people to choose between their faith and the law if it can be reasonably avoided. Plus, they noted that the Rastafari are a vulnerable minority group that actively needs protection from social stigma. But right as we hit the climax of this entire legal drama, a massive roadblock. As the court prepared to weigh these huge societal principles against each other, the judges realized they couldn't actually make a final, responsible ruling. Why? Because the most basic, ground-level facts they needed to make that constitutional call simply were not in the official record. It basically boils down to this. Both sides totally dropped the ball early on. Prince challenged the laws way too late in the process, which meant he never actually submitted detailed, hard evidence about Rastafari cannabis practices. And the state? Because the constitutional challenge came so late, they just threw out a blanket claim that police and exemption would be impossible without offering any concrete data to back that up. So while the Constitutional Court is scratching its collective head over this frustrating missing evidence issue, they stumble onto an entirely new legal mystery. Looking back at the previous hearing at the Supreme Court of Appeal, they noticed a procedural weirdness that literally threatened to throw out the entire previous appeal process. To understand why this is a big deal, we just need a quick definition of a quorum. A quorum is simply the minimum number of judges that have to be present for a court's decision to be legally valid. If you don't have a quorum, the judgment is a nullity. It legally never happened. And here is where it gets highly technical. Under an old 1959 Supreme Court Act, there was a super strict rule. If the Supreme Court of Appeal was ever questioning the validity of an act of Parliament, which is exactly what Prince was asking them to do with the drug laws, they absolutely had to have an 11-judge quorum. But here's the crazy twist. During Prince's appeal, the Supreme Court of Appeal only had 5 judges sitting on the bench. If that old 1959 law was still active, their dismissal of Prince's case was completely invalid. That would mean there was technically no valid judgment for the Constitutional Court to even review, potentially tanking Prince's entire years-long battle on a pure technicality.
Thankfully, disaster averted. The Constitutional Court solved the mystery. You see, South Africa's transition to a new democracy fundamentally rewired the courts. The new interim constitution actually stripped the Supreme Court of Appeal of its power to invalidate acts of parliament. And because they lost that specific power, that old 11-judge rule became totally obsolete. So a 5-judge panel was perfectly fine, and Prince's appeal was still completely valid.
Okay, quorum crisis averted. Now, back to the main issue, that missing evidence. Normally, court procedure says if you don't bring your evidence to the lower courts, you're out of luck. But the Constitutional Court took a stand. They decided it would be incredibly unjust to throw out a case of such immense public importance just because Prince lacked resources and made some procedural mistakes early on. Dismissing it would just kick the can down the road on a vital constitutional reckoning that affected an entire vulnerable minority group.
So, what did they do? Instead of just wrapping up with the final verdict and dismissing the case, they utilized their power to admit new evidence and threw down the gauntlet. They explicitly ordered Prince to provide the exact, granular details of how the Rastafari religion operates in South Africa. They wanted to know everything. How, where, and when is cannabis used? By whom? How do they get it? Are there internal leadership structures to prevent abuse? They needed to know if a religious exemption could actually exist in the real world without causing absolute chaos.
And, keeping things completely impartial, they turned right around and demanded answers from the state, too. No more vague claims. The court ordered the Attorney General and the Minister to provide actual, concrete proof of these so-called practical policing difficulties. Plus, they pointed out a massive contradiction. The current drug laws already allow doctors and researchers to possess cannabis. So the court basically asked, why can you manage medical and scientific exemptions just fine, but a religious exemption is allegedly going to make everything slip out of control?
So we're left hanging on an incredible constitutional cliffhanger. The court hit pause on a definitive ruling, essentially forcing both sides to come back with undeniable facts. And it leaves us pondering a huge, profound question that really strikes at the very heart of our justice system. When personal faith and state law inevitably collide, who actually carries the burden of proof? Does the believer have to prove their religion is safe, or must the state prove its laws are strictly necessary? It's a delicate balancing act and one that is quite literally still shaping modern democracies today.